Am I on? 910, Big 550, KTRS. Chris Hayes is joining Martin Kilcoyne a little bit later on to talk about this Pamela Hup story. Also, Don Lemon from CNN. John Carney is going to have the three Americans who stopped ISIS on a train. Also, the Johnny Law segment with Brown and Crouppen. And, of course, Frank Opinion. That's all up here on the Big 550 KTRS. Greg Willard is our go-to guy. He is our legal analyst. He is a St. Louis University law professor, and he joins us from time to time. And the KTRS Legal Analyst. Good morning, Professor.
Good morning, McGraw.
So everyone's talking about this Pamela Hup story. As a lawyer, as a professor, somebody who's watched this, what are your thoughts as you look at this story?
Frightening, puzzling, befuddling, pick your descriptive term, and it would probably fit. I think start with, I think the most important thing, 2 lives have been taken. The life of the wife,
right.
And then this young man who was unfortunately had been disabled for a number of years.
Right.
So let's remember them this morning. But to go then beyond that, this woman that they arrested yesterday, I think it will be fascinating, McGraw, to watch it play out in the courts. Is this a woman who is mentally disturbed out in the area of a John Hinckley, for example,
right.
or is she completely sane and just in the evil incarnate?
Yeah.
Remains to be seen, but I guess my descriptive term this morning would be bizarre.
You know, we were kind of joking before you got here. It's not really a laughing matter, but, you know, every time there is a terrible tragedy like a husband or a wife are killed, the husband is always the first one to be thought of as a suspect. In this instance, he was arrested, convicted, and anyone who looks at this, you sort of look at it and think, how was this man ever convicted when there were all sorts of alibis and issues that were sort of as plain as day?
Well, there is, stay tuned, I guess, is what I would say. You, as you know, McGraw, his conviction was subsequently overturned.
Right.
There are very, very serious allegations against the prosecution and law enforcement up in Lincoln County as to how that prosecution unfolded. So the husband, even though he was convicted, subsequently exonerated. So that's another part of this saga as to where the criminal justice system apparently failed grievously for him. But you're right, he became a suspect, and the allegations are that he was railroaded. We'll see whether that proves to have been true.
Yeah. How about the fact that she took a pen? Was that? I mean, clearly, when you're locked up, don't they make sure you don't have anything sharp near you, so you can't hurt yourself?
Well, normally there's a pat-down search. I think if you look at a photograph of her yesterday, she has her hair pulled back on her head. That was the first thing I thought of when I heard that she had attempted to take her own life, that she maybe had concealed a pen up in her hair.
Right.
Or maybe she had concealed it elsewhere and they just didn't get it with the initial search.
Yeah. All right, Greg Willard, professor at St. Louis University Law. Let's go to class here. In Texas, judge overturned a transgender bathroom law. Fill us in. What's going on here?
This goes back to May of this year when President Obama, acting through the Department of Education, sent a letter to every public school in the United States,
Right.
telling them that it was the position of the Department of Education that public schools could not require students who identified with another gender to only use the restroom facilities of their biological gender.
Came from Washington to every school district in America.
Every school district, and you and I think were on the air the morning that the letter leaked.
Right.
What has happened is there has been litigation in North Carolina and Virginia. We can speak to that in a moment. But what happened was 13 states filed a lawsuit against President Obama and the administration in Texas. Yesterday, a federal judge in Texas ruled that President Obama cannot require public schools to allow transgender students to use restrooms and locker rooms of the sex to which they identify. What is most significant, what happened yesterday, McGraw, it was more than just a ruling. The judge entered a nationwide injunction enjoining President Obama and the Obama administration from enforcing their interpretation of this law.
Okay.
And that's very different from what has happened with these issues in North Carolina and Virginia. But if you remember some earlier discussions we've had about immigration, it's exactly what happened in the immigration context when a different federal judge in Texas issued a nationwide injunction against President Obama as to his immigration actions.
So does this judge have the right to do this if he wants to?
Oh, most certainly he does.
Okay.
A federal judge certainly has the power, whether he properly exercised at the Court of Appeals, and maybe the Supreme Court will tell us. But yeah, he certainly was in his power to enjoin the president and the administration.
And what did he say? We're just going back to the way it was? Did he say we're going to study this more? What was the underlying
Sure.
thoughts?
This stems, McGraw, from a statute we hear most often referred to in the context of collegiate athletics, intercollegiate athletics, Title IX.
Mm-hmm.
Title IX provides that there cannot be discrimination as between men and women in the normal context in athletic and other things, but it also applies to facilities in public schools and public universities. What the statute refers to uses the word sex. The plaintiffs, the 13 states, said that means your biological sex at birth.
Mm-hmm.
What President Obama and the administration has said is no. What that means is your biological sex or the gender to which you identify.
Right.
So what the court yesterday held that President Obama and the administration erred in two respects. One, they did not follow the procedure to set a new regulation. The Administrative Procedures Act was violated. But more importantly, they said it doesn't matter. The judge said it doesn't matter because the statute on its face is very clear, and it uses the word sex, and that was understood by Congress when they passed the law to be biological sex, and
right.
Therefore this identity is not applicable.
So what happens now?
I suspect it will be appealed to the Fifth Circuit Court of Appeals. In the meantime, the same issue is under review in North Carolina. In Virginia, and then the Fourth Circuit Court of Appeals had ruled in favor of the Obama administration's position.
Okay.
That now is pending before the Supreme Court, but the Supreme Court has stayed that ruling. So I think where we're headed, McGraw, is probably later this year you and I will be sitting at this table discussing probably a ruling by the Supreme Court. Unfortunately, it may be a 4-4 tie, my friend.
Wow.
And we will go back then to our discussion about what the Supreme Court did on the immigration statute.
Life goes on, but the Supreme Court does not.
Does not. Merrick Garland sits patiently by in Washington.
Greg Willard, let me ask you a question because in my limited knowledge of the law, we are a nation of laws, but these laws affect people. And these are real people with real issues. And so there's a teenager who is a woman, was born a woman, has woman parts, dresses as a man. And so now this judge ruled that this transgender student must go to the bathroom in a woman's restroom.
Mm-hmm. Correct.
So your daughter is now going to the bathroom next to someone who dresses and looks like a man, but is really a woman.
Identifies as a male.
Right.
Correct.
And so your son might go to the bathroom next to somebody who looks like a woman, dresses like a woman, but is biologically a male.
Yes.
It seems to me like, and again, it would be easier to allow, if you look like a girl, to go to the girls' room, and if you look like a boy, go to the boys' room. That would be more sort of normal in a situation like this.
Two aspects of that. One is the practical, the social aspect, if you will. The other is the legal. Let's take the social. I would change your hypothetical just a little, McGraw, and let's take it into the locker room.
Okay.
So you have a biological female, 16-year-old.
Right.
She is identifying as a male. It is the position of the Obama administration that she should be entitled to use the locker room facilities of the boys' locker room. Mm-hmm. And these 13 states said no. So in your hypothetical, you're talking about the restroom facilities and the uncomfortableness. Well, in a different context, there would be a different level of uncomfortableness. From a legal standpoint, and this is where I think everyone needs to take a deep breath, we're not talking about constitutional issues here, McGraw. We're talking about a statute, Title IX. This is why we have elections. If the majority of the American people in our democracy believes that the Obama administration's position is correct or the state's administration, they can express that at the ballot box and Congress can clarify Title IX. But these are the types of issues in a democracy where judges ought not to be deciding, with all due respect to this judge in Texas.
Right.
This is why we have elections, and the American people should express themselves as to answering the question you just posed.
Greg Willard with us. By the way, we know where Hillary stands. She stands with the Obama administration. Donald Trump, I don't know if it's been asked, but has asked if Caitlyn Jenner was allowed to go to the bathroom in Trump Tower, where would she be allowed to go? And he did say that Donald Trump said that Caitlyn Jenner would be able to use the women's restroom in Trump Tower. Funny, because Caitlyn Jenner supports Donald Trump in this election. Professor Greg Willard, St. Louis University law professor. We'll come back. We'll talk about Hillary's emails. 9:21 here. Big Five. Willard, our guest, KTS legal analyst. We've held him over for another break just because Hillary's emails have they just keep coming and they never end. Oh my goodness, Greg Willard. I explain to me legally where we are with these new emails. The FBI, the State Department, they have looked at them. They were deleted. Now they're found. Now they're back, and who knows what. I mean, where are we with all this?
Oh, how do you spell mess, McGraw? But let me see if I can set the stage. This all emanates from Secretary Clinton's decision in 2009 to use a private email server in the basement of her home in Chappaqua for all of her official and personal email. It turned out that she had about 65,000 emails on that server. She turned over to the State Department what she said were the official ones, 31,000. She deleted, and she thought she had destroyed the other 34,000. The FBI did an investigation, and Director Comey several weeks ago reported to the Congress on their findings. What has happened is, and what has reignited this controversy, is the FBI has turned over to the State Department 8 computer disks. One of the disks has the 31,000 official emails that she said she had given.
Right.
There is another disk that has 14,900 emails that Secretary Clinton destroyed, she thought, and the FBI was able to reconstruct them.
Right.
So those 14,900 presumably are part of that 34,000 that she claimed were personal. So they have turned those over to the State Department to review to see if any of them contain official correspondence or documents. Then, as to the other 5 emails, what is puzzling, and a lot of the pundits have jumped on it, is the Justice Department said in one of the lawsuits that on the other 5, there are, quote, tens of thousands of emails on those other 5 disks.
Right.
Well, now we get into the world of, well, wait a second, Mrs. Clinton, were there really 65,000 emails, or were there a lot more? So what I think, once again, it's to use Donald Rumsfeld's phraseology, it's the known unknown and the unknown unknown, McGraw. But it is a cacophony of noise around Mrs. Clinton. It reminds me, you and I are old enough to remember the old Peanuts cartoon.
Yes.
And he had a buddy, Pigpen.
Yes.
And Pigpen would walk down the street, and there was this whirl of dust and debris behind this little kid. Well, that kind of reminds me of Clinton world these days, is wherever they go, wherever the Clinton Foundation, there just seems to be this whirl of controversy and mess.
Well, going forward, though, we have to come up with a way, because Republicans are entangled in this as well, whether it's State House or whatever else. There's got to be a way we communicate with email. You know, Jay Kanzler is a friend of mine, but I deal business with him on email. So he might say, hey, let's go to lunch. I want to catch up. How are things going? Plus, I want to be on your show. That's a personal and a business email. And so do I do that on my work email? Do I do that on my personal phone? She has a life, and she's dealing with top secret information, plus Hillary's, a grandmother. So she wants to see pictures of the granddaughter. Whereas, so I guess my question is, we have to sort of agree somehow, or agree on some set of rules where these private emails are allowed to be private, but they can still conduct business. You know what I'm saying? I mean, there's got to be some type of system set up.
Right, and I don't, with all due respect to Mrs. Clinton, I don't think it's this complicated, and I think the controversy that has erupted around former Secretary of State Colin Powell, but I think we can take a chapter from his playbook. The answer to your question, and I think what Secretary Powell used, is, okay, Secretary of State McGraw Milhaven.
Right.
You should have at least 2 email accounts. For your official emails, you use your state.gov and the encryption and protections that it's provided.
Right.
And if you and your pal need to make arrangements to meet up at a baseball game, use your AOL account.
Right.
Use your Gmail account.
Mm-hmm.
That's what Secretary Powell did, is he had an AOL account for personal email. Mrs. Clinton, on the other hand, she went completely in a different direction.
Right.
She had one private email account, and it was on a private email server, not AOL or Gmail.
Right.
It was clintonmail.com in her house.
Okay, so then the Fresh Prince of Bahrain, or the Crown Prince of Bahrain, wants to meet Hillary using her connections from the Clinton Foundation. She sent it to the private email. Is she sending it to the private email of the Secretary of State using business, right? So that's her private, but it's her business. So, you know what I'm saying? I mean, business and private are sort of so intertwined now, you can't have one without the other.
I guess I would disagree with you. I think you can, and I think it's not too much for the American people to ask a public servant to make that judgment when they are communicating.
But then private emails will remain private,
sure,
and the public doesn't get to see them.
Correct. The public, that is not part of the public business in the public square.
But how do we know then something nefarious isn't going on through that private email?
Well, that's why you have to place trust in the public official, and if the public official violates that trust, he or she ought to be punished.
Of the emails that have been exposed, whether it's this Joyce Abusi here in town or this Bahrain prince or whatever else, a lot of people are pointing, saying, aha, that's proved, look how dirty she is. Is there a smoking gun in there at all?
Apparently there is no smoking criminal gun. There may be very egregious smoking political guns, the sort of the pay-for-play allegations that are being made. But let's be clear, and I think a lot of the conservative pundits at least are overlooking this. They think that somehow there's a smoking gun in this 14,900 emails that have been turned over to the State Department. McGraw, the FBI has already read every one of those 14,900 emails, and as we heard Director Comey a few weeks ago, conclude, while she was excessively careless, she was not grossly negligent in a criminal sense. So I don't expect there to be any criminal smoking guns, but political, passing the smell test, the pig pen character, there may well be.
I will leave you with this, Greg Willard. I do find it interesting that both Democrats, Republicans, conservative liberals are all hypocritical on this. In one instance, they'll bag on Rex Sinquefield for giving millions of dollars to somebody, but they won't say bupkis when George Soros dumps a whole lot of money into a Democratic campaign in the city of St. Louis, and vice versa.
the hypocrisy of our campaign finance laws and the related laws has no bounds, my friend.
Ladies and gentlemen, that's why he is a professor at St. Louis University. He joins us from time to time, KTRS legal analyst and Professor Greg Willard at St. Louis University Law School. Get back to work. Thanks for checking in.
Always good to be with you, my friend.
9:34, Big 550.